Top of the morning, Dan and Amy. So you generated some responses from Mr. 10%, the big guy, President Biden, and his spokeshuman, KJP, responding to the Supreme Court decisions handed down on Friday that eliminated his student loan forgiveness by executive fiat and also upheld, unsurprisingly, the religious liberty of a graphic designer in Colorado. I mean, it was almost right on point with the Masterpiece Cake Shop case, the Jack Phillips cases over the years.
Right, but everybody acted so surprised, so outraged.
It's literally
obvious.
the same dynamic.
Right.
And we'll get to that. Here's the big guy explaining, well, not really explaining, just stating, because that's what he does, that Supreme Court doesn't understand the Constitution. They got the Constitution wrong when it came to his loan forgiveness of up to $20,000 for those who make $125,000 or less.
Mr. President, why did you give millions of borrowers false hope? You've doubted your own authority here in the past.
I didn't give any false hope. The question was whether or not I would do even more than was requested. What I did, I thought was appropriate and was able to be done and would get done. I didn't give borrowers false hope, but the Republicans snatched away the hope that they were given, and it's real hope. Thank you.
Mr. President, will you cancel?
Did you overstep your authority? Did you overstep your authority?
I think the court misinterpreted the Constitution.
Mm-hmm. And KJP, of course, the additional pain of this Supreme Court decision in the 303 creative case coming down on the last day of Pride Month. Personally hurt by that.
We are deeply disappointed in the Supreme Court's decision today in 303 creative, which takes our nation backward in the fight for equality. This decision undermines the basic truth that no American should face discrimination for who they are or who they love. And it's even more disappointing as we close out Pride Month today. It chips away at a long-standing laws that protect all Americans against discrimination in public accommodations, including people of color, people with disabilities, and people of faith, and women. While the court's decision only addresses expressive original designs, as President Biden said today, we are concerned that the decision could invite more discrimination against the LGBTQ+ community. And we know that when one group's dignity and equality are threatened, the promise of our democracy is threatened, and we all suffer.
Right. So everything's a threat to our democracy. Everything we disagree with is a threat to our democracy.
Governor Pritzker released a statement, and Brandon Johnson echoing the same sentiment.
Yeah, because they're, KJP is just a moron. She doesn't know anything. J.B. Pritzker is a craven political hack, and Brandon Johnson somewhere in between. Just to make this real simple, I mean, Randy Barnett will make it simpler, but the Jack Phillips case, not that he wouldn't, just to refresh your recollection, not that he wouldn't serve LGBTQ customers. You want to make a birthday cake for a relative? No problem. You want me to make a wedding cake for a ceremony that violates my religious beliefs? I can't do that. Same thing here. You want me, you're a gay person, and you want me to make a website for some association or charity you support or something like this? No problem. You want me to make a website that specifically promotes something that is at odds with my religious beliefs? That's where you have a problem. It's not the person. It's compelling the expression. And it's actually sad that you have 3 Supreme Court justices who can't understand that distinction. Sort of basic First Amendment protections here, at least in my view. For more on this, pleased to be joined by Randy Barnett, Georgetown law professor, author of Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Randy, thanks for joining us again. Appreciate it.
Hey, Dan, it's good to be here. You sound so sad and you sound so down. You seems like you should be up a little more upbeat this morning.
Well, I mean, well, first of all,
we'll go over that later.
First of all, it was anticipated. I mean, all these decisions were anticipated. There's no surprises. And secondly, as you know, there's what the Supreme Court decides, and then there's the culture battle that ensues to actually implement it. Brown v. Board of Education wasn't implemented overnight, and now we have a culture that's trying to undo it for all, in the of all things most absurd. So, I mean, that's the point here is not about being happy or sad. It's about dealing with the sort of, ignorance that you hear from people like KJP and the president.
Well, I do get that. Well, you say it's not a surprise, but I think there were a number of people who, having seen some of the earlier opinions issued by the court earlier in June, started to get nervous that these cases might not come out the way they come out, the ones that were decided on Thursday and Friday. So to some people, it was kind of a relief that they ended up coming out the way they did.
Well, sure, but for example, good piece by a scholar from the American Enterprise Institute in the Journal over the weekend. This victory against socializing student loan debt may be short-lived because the Department of Education is already promulgating all of these student loan forgiveness strictures that will sort of end run what the executive order that Joe Biden issued attempted to do. It's Obamacare redux. We're going to get through the back door while we can't get through the front.
Right. Well, there is a pattern of resistance to judicial rulings that we have seen in recent years, and with these particular cases, it's likely to get worse. But let me go back to another issue that you raised, which is whether these were a surprise or whether they are straightforwardly right. And in both the cases of 303 Creative, which was the website design, and Students for Fair Admissions, which is the affirmative action case, both of these decisions did go a bit beyond what the court had been willing to do before, and therefore represented progress for those people who think this is the right answer. That was not exactly in the previous cases, although had been signaled in the previous cases. So in the case of 303 Creative, in the Masterpiece Cape Shop, as you'll remember, I actually attended the oral arguments in that case. They decided not to address the free speech issue in that case, which is I had a brief saying that this should be a free speech case, and I had a brief in 303 Creative as well that said the same thing, a brief of law professors. But they decided to go off in that case on the animosity or animus that was being shown towards Jack Phillips by certain members of the Colorado Human Rights Commission.
Right.
And for that reason, it was a very narrow decision and never really reached the free speech issue. It was based on anti-religious animus. So this case does reach the free speech issue,
which is why they picked it up. Which is why they
right,
granted cert. Yeah.
Exactly, because with Justice Kennedy being replaced by Justice Kavanaugh, Justice Kennedy was the swing vote in Masterpiece Cake Shop, and with Justice Kavanaugh replacing Justice Kennedy, now we've moved to a 6-3 situation with Justice Roberts now joining the 5 other conservatives to get us to this result. Similarly, in the affirmative action case, the previous case of Fisher 1 and Fisher 2, while the court did say that the use of racial classification should be given strict scrutiny, in Fisher 2, the second of the cases that went up to the court from the University of Texas, Justice Kennedy once again deferred to the University of Texas on whether racial classifications were necessary to achieve what it claimed to be diversity. Again, with this case, applying strict scrutiny for real, they found that the Supreme Court found that affirmative action was not necessary to achieve a compelling state interest, and in fact was itself violative of the Constitution to use race in this way. So that was a major step forward. Again, enabled by the fact that Justice Kennedy was replaced by his former law clerk, Justice Kavanaugh, and then at that point, Chief Justice Roberts joins the 5 conservatives, making it 6-3, rather than making Chief Justice Roberts the swing vote.
Here in the Academy, I mean, we heard we played on Friday. It was circling the web. The dean at Berkeley Law School talking about how they do workarounds when it comes to considering race in hiring decisions. He's obviously on the hiring committee, and so it's a wink and a nod. I mean, we all know why we're here. We all think the same thing, so just don't say it out loud. But we all know what we're supposed to do, and that's obviously the culture on most college campuses. And so, your sense of how this will actually translate in terms of real world impact, the college admissions decisions.
It's not going to be the last word. The person who that video was with, Dean Erwin Chemerinsky,
Right.
who is actually a distant relationship of mine. He was a year behind me at Northwestern and a year behind me at Harvard Law School, and started his teaching career at DePaul in Chicago before he went west. I think he was saying the quiet part out loud. We can expect institutions of higher education to do what they can to get around this ruling, as schools have been doing in California and Michigan, where there were constitutional amendments put into their constitution barring the use of race in admissions and for other uses. And yet, nevertheless, we think that's been going on in those cases anyway. But this additional lawsuits when this sort of practice is found. What you notice in the face of massive Democratic resistance, which is also what they did to the Brown case, that it takes a lot of work and effort to move forward. But a Supreme Court opinion like Brown, which, as you noted, did not get implemented right away due to massive Democratic resistance, it did make a difference. It was.
But what does this mean? I mean, Harvard University, the acting president, she came out with a video late yesterday, I do believe, saying that. Well, she said that they're still going to use race in admissions. I mean, they noted they're going to follow the law, but it's still going to consider race among other factors for applications.
Well, the opinion did give them a bit of a out that's now going to have to be litigated in follow-up cases, and that is saying Chief Justice Roberts, who otherwise was very good on this issue, saying that this was not going to prevent colleges from considering essays in which students identify their
Right.
own
The rivals
identity.
And Biden's the adversity. We're not. You will use adversity instead of diversity. We'll have diversity statements. I mean, right. The obvious workarounds that you say that are in operation right now in certain states, and that they're prepared for this, of course.
Well, they're also, the other thing that we've been seeing in the year building up to this after oral argument is a reduced reliance on test scores like the SAT score or the LSAT score, and I think that was in anticipation of what the ruling was going to be here, so that there would be less ability, for example, of Asian Americans to demonstrate that, objectively speaking, they were being discriminated against on the basis, which could be established by comparing their test scores and GPAs with the other admittees.
What do you think the implications are in terms of, you mentioned that this will spawn more litigation, and you're right, and that will be interesting to see how the court ultimately adjudicates challenges to race-based policies at the K through 12 level. Race-based policies and within corporations that receive any government funding, minority contracting preferences in municipalities, all of those categories of race-based policy implicated in this decision?
Well, it's going to depend on a lot's going to depend on whether the court is prepared to hear follow-up cases. We see in the gun rights domain, Dan, as you know. After Heller and after McDonald, Heller recognized individual right to bear arms against the federal government. A right against the federal government to bear arms, and McDonald extending that right to the states. We had 10 years of massive resistance, but not only by states like Illinois, which is continuing on to this day, but by the lower courts, including courts that are supposedly conservative, like Judge Easterbrook on the Seventh Circuit, essentially trying to say, make us, we don't like this, and we're not going to go along with it. And the court just last term had to decide the Bruin case, in which they they said that we really mean it. But even the Bruin case is now engendering some pushback as well. So this is an ongoing process. As I say, we've seen that sort of resistance dating back to Brown versus Board of Education.
Yeah, and of course, you have hysterics on the left, distorting the discussion, and so it becomes the cultural battle that I was describing. But
I do think that we should focus on the good news here, and that is that as I think I mentioned to you during the aftermath of the Obamacare case, where I was one of the lawyers, it turns out that having 5 votes, 5 conservative justices, is not enough. Because if you only have 5 votes, then one of them is going to be the compromiser. All the pressure is going to be put on that 5th vote to come out the, quote, right way, and then they will tend to break. And it was Justice Kennedy. They took turns being the 5th vote. Sometimes it was Justice Roberts. But if you get to 6 votes, the dynamic completely changes. Because at that point, the person who might otherwise have broken, be it a Chief Justice Roberts or what it would have been a Justice Kennedy, now has a decision to make. Are they going to go with the 4 dissenter justices, or are they going to join the majority of conservatives and make it a more than a 5-4 vote? It'll now be a 6-3 vote, and we've seen that dynamic now play out, where 6 conservative justices, and I do count Chief Justice Roberts as a conservative. I always did, even if he ruled against us in the Obamacare case for what I consider to be bad reasons. This turns out that 6 justices is hugely different than 5 justices.
Well, the dynamic, the game theory dynamic here is Roberts doesn't want to lose the court. And if he's not with the majority in these cases, he starts to lose the court effectively. So, whatever incentivizes him to be more courageous than he's otherwise inclined to be, and not just the Obamacare case, but I agree. There's no question, and obviously this is a feather in Trump's cap, since we're in the context of a presidential campaign. If I were President Trump, I'd be running around reminding everybody that Gorsuch and Kavanaugh and these decisions on affirmative action and student debt forgiveness and religious liberty are because of the appointments I made.
Well, it is definitely a feather in his cap. It's a feather in the cap of Don McGahn, who was his White House counsel and stood behind the nominees, and it was a feather in the cap of Mitch McConnell, who saw all 3 of these nominations through, even though each one of them presented their own difficulties in getting them through. Anyway, it's a very important. You raise a good issue. This is a hugely important issue for 2024. If you want to see decisions like this continue, it's going. I think it's going to be quite necessary for there to be a Republican president, regardless of whether that is President Trump or President DeSantis. I should say Governor DeSantis. Well, and that's otherwise this is going to be a temporary phenomenon.
Right, and it's essentially indicated as such by some on the left responding with all of what you've heard in the run-up to this, baseless allegations of essentially Supreme Court Justices Thomas and Alito being compromised, AOC over the weekend invoking the prospect of impeachment. Not that that would go anywhere, but it's all designed to suggest that the Supreme Court is not legitimate because it's not deciding cases in the way that AOC would. Hardy har har.
They wouldn't be doing that if they thought they were going to get the court back in the short term, because they wouldn't want to delegitimate the institution that they then want to control and use for their own purposes. But it's because they anticipate they're not going to be getting it back that they've now decided that we don't really need the Supreme Court after all. And all the decades in which they said, if you don't like the rulings of the court, then you're going to have to get different justices on the court. That was all cheap talk. In fact, the court needs to rule their way, or it's a nice little court here. Too bad if something were to happen to it.
Yeah, exactly right. Good point. Randy Barnett is Georgetown law professor. He's also the author of the book, Our Republican Constitution, Securing Liberty and the Sovereignty of We the People. Professor Barnett, thanks as always. Appreciate it.
Thanks, Dan. Thanks, Amy.
Thank you. And he joined us on our turnkey.pro answer line.
Listen to Dan and Amy on your smartphone. Download the AM560 mobile app today at 560theanswer.com/mobile.
This is Carol Platt-Liebau for townhall.com. It's fitting that the Supreme Court has decided 303 Creative LLC versus Elenis in June, LGBTQ Pride Month. Like the well-known Masterpiece Cake Shop case, 303 Creative explores the tension between LGBTQ public accommodation rights and a business owner's First Amendment right not to be forced to use her creative talents to express a message violating her religious convictions. Thankfully, the majority has vindicated Colorado website designer Lori Smith's First Amendment freedoms, holding that she can't be forced to create sites at odds with her deeply held religious beliefs. Colorado